Well, I want to thank Mike and Mike for inviting me to give this comment on John's paper. I noticed that for some reason the USD has not supplied us with little bottles of water for the speakers to lunge towards if we have dry mouth up here. If we start to choke, I guess we just have to choke. And yeah, it's for our own good. I mean, we just wouldn't want to have us take any drinks of water while we're up here. So at any rate, it's great to be here. I love the opportunity to talk about John's paper. I just think John's paper is terrific. It's a very fine piece of work. I think it's careful, it's balanced, it's nuanced. I just find it very interesting, the basic thesis, very interesting that he's able to balance off numerous statements that some of us were already familiar with about the need for a clear conflict between the Constitution and a law of Congress with an affirmation that judges should robustly use all the techniques at their disposal to figure out what the Constitution means. It's a major contribution, and his critique of Thayer is a major and welcome contribution. Now, my job here as a commentator is to come up with comments that are more critical than that, so I'm going to try to fulfill it. Let me just begin by saying that I think there's some questions that can be raised or asked about what exactly he's shown in the paper and how it relates to originalism. How much, for example, does his analysis depend on accepting, for example, the original methods approach to originalism that he and Mike have spent so much time developing? I remain skeptical of original methods originalism, but I'm trying to reserve judgment on that issue until I see more about what original methods are supposed to be, were supposed to be, what the evidence for those original methods are, and how we know and how we discover these original methods. So I kind of want to see more about how the theory works in operation before I'm prepared to decide one way or the other. Perhaps one of the functions of this paper actually is to begin or at least contribute to a development of what original methods are. But if so, I think that's still sketchy to me, and it's sketchy to me even in the context of the paper itself. I still personally think of original methods originalism as a theory of construction, not a theory of interpretation. That is, I think although some pervasive background assumptions about method could in principle affect the communicative content of the text, I'm not sure that many of them do, and I think not maybe all of the ones that John and Mike would hope to advance are actually part of the communicative content of the text itself. Mostly I think what evidence of original methods is evidence of how people at the time of the founding and thereafter engaged in constitutional construction, and then obviously that gives rise to the question of why, if at all, we should be in any way bound by the way they did constitutional construction. We do constitutional construction today. But I really just wanted to get this on the table. I did not want to make this the focus of my remarks. I want to bracket this concern. But I did want to at least register this note of question about the paper because it's not really the subject of this paper. And I think that it may also be possible that what John is showing us in this paper is highly relevant to the precise scope of the judicial power under the original meaning of the judicial power, and it's just a straightforward originalist effort to define that word. And so let me, in the balance of my remarks, just discuss a couple of issues I have with the paper taken on its own terms without questioning its relationship to original methods. And I hope that these remarks will be considered as constructive suggestions for strengthening the argument rather than any attempt on my part to refute the argument that John is making in his paper. So first I would begin, at least briefly, by noting that John, in the beginning of his paper, distinguishes between restraint, judicial restraint, in two separate contexts. And I would just quote from page 3 of the paper where he says, "Moreover, this analysis considers deference only in the context of interpreting the language of the Constitution. The Constitution may require Congress to provide proof to underpin the implicit factual claims of legislation, and this essay does not consider the degree of deference congressional fact-finding should receive," that congressional fact-finding should receive. So there's basically two venues in which deference might be exerted. One is in figuring out what the meaning of the text is, and the other is in figuring out whether that text has been applied properly in a particular case. And John's paper is about the former and not about the latter. Now, I think this is an extremely important distinction. I'm very glad that he makes it at the beginning of his paper because I think it helps us understand what the rest of the paper is about. But I do wonder whether it isn't the case that much of the modern debate over judicial restraint actually concerns the latter, that is, the degree to which judges should be restrained in questioning how Congress has applied the meaning of the text to particular cases, rather than the former issue, which is a disagreement over the meaning of the text itself. And I also don't know how much debate there's actually been historically between Congress and the courts about the meaning of the text. So that's some of the questions I have about, once you appreciate that, once you think that there's these two different venues of restraint, I'm not sure how big the category is of what's going on in the first category of restraint, which is disagreement over the meaning of the text. And therefore, I'm not sure how significant the rest of the paper is in the context of modern debates over the meaning of judicial restraint. I'm also not exactly sure, I'd have to go back and read the context of the quotes to know this myself, from the quotes that as they're presented in the paper, how many of the statements about clear conflicts that John talks about were actually concerned with interpretation of the meaning of the text, and how many of those came in the context of being concerned about the application of the text to particular facts, which is not really the context of the paper. I mean, for example, one way to understand the debate over the constitutionality of the bank, and it's the way that President Jackson professes to understand it in his veto statement and in his understanding and reading of McCulloch, is that the real issue is really whether the bank was necessary. Not what the meaning of necessary was, but was the bank necessary? And one of the arguments one of the ways of construing Madison's acquiescence to the bank is that he's decided that, look, lots of people have decided it's necessary. I'm willing to defer to the idea if it's necessary, even though I don't like the reasoning in McCulloch versus Maryland very much about what the meaning of necessary is. I'm still willing to say it, based on existing practices, it's decided that it's necessary. So that's really in the second category rather than the first category that John addresses. Okay, I have something else here. Well, I guess one other thing I'll just touch on briefly. I've only got. Are you signaling I have a time problem here?
I want to get on the queue.
Okay. Let me just highlight this distinction using one other example from history, and that is that Lysander Spooner and Frederick Douglass offered a principle of construction when the meaning of the text was at issue or was ambiguous. And they took that principle of construction from a principle of statutory construction that Chief Justice Marshall had offered in U.S. versus Fisher, and it was this: where fundamental principles are overthrown, when the general systems of laws is departed from, the legislative intention must be expressed with irresistible clearness to induce a court of justice to suppose a design to affect such objects. That's Marshall in Fisher. It's a statutory construction case, but Spooner and Douglas offer this as a constitutional approach or a constitutional presumption that should be applied when the meaning of the text is unclear. By contrast, the presumption of liberty that I argue for in my book is really, I'm not exactly sure I thought of it in these terms when I wrote the book, but thinking about it now, I think it's really more about the deference to Congress's application of the meaning of the text to particular controversies to see whether in fact they really is necessary and proper for example, for courts to impose economic mandates on the people in order to effectuate a larger economic scheme, something like that. So that's the sense in which I think this is something that John needs to think about. Now, apart from this issue, though, I just want to make one further point, at some length perhaps, but just one. I have basically one further point to make, and that is how the paper is framed. It is basically framed by generally accepting the post-New Deal understanding or framing of the issue of judicial review. Let me start with the following observation. In none of the sources that John discusses does the word restraint actually appear, at least none that I saw, none that I noticed. So the word restraint itself is not in the sources that he's talking about, and this suggests that it may actually be anachronistic to read anything like the modern conception of restraint into the founding era. And in fact, John's sources might not best be understood with reference to that concept. By the same token, this was also, in some respects, the principal thesis of Philip Hamburger's book, which John cites with approval, and that is that the power of judicial review is also not in any of the original sources. In fact, what you see in the original sources is the duty to obey the law. It's a duty, not a power, and therefore it's anachronistic to read the power of judicial review back into the original sources, notwithstanding the fact that there was this duty. When do we first get discussions of the power of judicial review? We start getting these discussions, I believe, I haven't really done the work, but I think it's true to say, that we start getting them with the progressives. And we might ask the question, why do the progressives start developing this idea or start speaking in terms of the power of judicial review? And I want to consider the answer to that question a little bit before I close. And I will just notice that in addition to using the modern concept of restraint in his paper, John also, although he repeatedly cites Phillips' work, and properly so, he does also adopt the language of power of judicial review throughout the paper. So let me suggest why these two concepts, both of which are anachronistic or potentially anachronistic when read back into the past, might actually be connected to each other, and then after that I'll be done. So first, a power, if you conceive of what's going on here as a power of judicial review, obviously powers can be exercised and maybe ought to be exercised with discretion and with restraint. All our powers should be exercised with discretion and restraint. Formulating as a power invites the idea of restraint. Would we really say, however, that one should be restrained in adhering to one's duties? That that's a virtue, to be restrained in adhering to the duties one has? The concept of restraint just doesn't mesh as well with the concept of judicial duty as it does with the concept of a power. Secondly, one of the other legacies of the judicial trope, the judicial power trope, is the claim, once widely accepted by latter-day progressives and by many conservatives, perhaps up until now, maybe not as much, but when I was growing up, it certainly was, and even a junior professor accepted, and that is that the power of judicial review was invented by John Marshall in Marbury versus Madison. It was a figment of his imagination. He made it up. I think this is something that does go back to the progressives saying that about judicial review. But if it's invented, of course, that means it's of dubious legitimacy. And if it's of dubious legitimacy, it ought to be this power ought to be exercised in a highly restrained fashion, because it really doesn't really belong there at all. Another argument for restraint that comes from the trope of power. If it's now the case that it turns out that there's very well established that the judicial duty to follow the higher law as opposed to the lower law is really what was meant, then again, restraint doesn't seem to fit this picture. Related to this claim is the fact that the power of judicial review is counter-majoritarian, another reason why it must be exercised with restraint. But if we now see that it's a duty to follow the higher law in order to hold the agents of the people responsible or according to the rules that have been laid down in order to govern their conduct, it's not clear that restraint is the appropriate stance one should take with respect to that duty. And finally, the modern judicial restraint trope, I believe, is oftentimes used to shift attention away from the meaning of the text to the issue that's really separate, and that is the issue of judicial role. Take, for example, Justice Scalia's dissenting opinion in Troxel versus Granville, in which he concedes for the sake of argument, not for the sake of argument, he actually affirms that this is true, and that is that the right of a parent to raise their child as she sees fit is a right that's retained by the people to which the Ninth Amendment refers. Nevertheless, he says, it's not my role as a judge to either identify that right or to enforce that right. But you notice what this does is it shifts attention away from the meaning of the Ninth Amendment, away from the meaning of the text, to the issue of judicial role. And in that case, restraint is actually, and the emphasis on restraint is moving away from originalism and the meaning of the text as a theory of interpretation to how judges ought to behave, really in disregarding original meaning, because they really, in their capacity, shouldn't be trying to pursue original meaning. They should be doing something else. So, at any rate, that this really culminates in a suggestion to John that I think the paper is extremely valuable, and I love the evidence that he's uncovered and the way he explains it and the even-handed way in which he does so. But I think he ought to at least think about the sense in which it is too heavily situated in our modern discourse about restraint in a way that would mislead readers into thinking that's really what the paper is about, and it has more to say about the modern view of restraint than I think it actually may have. Thanks.